SJC-12980, R.H. Mandeville v. Erin Gaffney.
Hi, good morning.
Good morning.
Mr. Curran.
Yes, may it please the court, Dana Curhan for R.H. Mandeville. We contend that that this court should apply the 30-day time limit reference in Maine's to all pending cases, but we contend that this court should do so after a sunset provision, after 30 days. So in other words, 30 days after this court decision comes out, any pending gatekeeper petition should be filed.
That's what Justice Spina. That's what Justice Spina said in Nassar a few years ago, though, right?
Well,
Justice opinion.
I think Nassar was sort of a different situation. Nassar was a case where it was sort of Maine's was referenced indirectly, but he had filed a motion for new trial. He filed a gatekeeper petition. He then sat on it for 25 years after it was dismissed for lack of prosecution and tried to resurrect it.
But I think when you read, at least as a single justice, what Justice Spina wrote was, as he interpreted Maine's, was that once Maine's came out, there was this 30-day period to call in all markers, so to speak, of all outstanding motions. And then after that, there was a procedural default. But you're asking us to do that now, in this case too.
I don't think that's a fair interpretation of what Maine said. Maine said here and after. Now we have two federal judges who have looked at this and said, you know, we think we have a problem. We think there's no time limit. There may be no time limit as to these pending cases. And it is crucial in a habeas case where you have a statute of limitations.
No, I understand your argument. What I'm trying to get at, Mr. Curran, which is the second part of what you asked us to do, was that you want us to announce that what we really mean at this time is 30 days after this case.
Well, yeah, I think probably when Justice Abrams wrote Maine's, she probably assumed, and this court assumed, that there weren't many pending cases where there'd been a decision on a motion for new trial, and but she didn't address it. What the decision said is here and after you have 30 days. So if you file a motion for new trial after Maine's was decided, then you have 30 days to do a gatekeeper. It does not speak to whether that applies to motions that were already pending and that were still open. You know, if you take a look at the closest analogy is the habeas statute. Originally, there was no statute of limitations. When the court enacted the statute of limitations, they said, but for cases that are already pending, there's a 1-year sunset provision. So you have a year to bring in all these other cases. You don't have that here. And that I think is the problem. And when you have a lot of these habeas petitions are done by pro se litigants. When they take a look at Maine's and they say here and after, that seems to mean anything filed after. So for example, Mr. Mandeville filed 10 motions for new trial, about half of them before Maine's and about half of them after. Of course, anything filed after Maine's would be subject to that 30-day provision. But the earlier ones, you know, a litigant, a pro se litigant, in this case, a couple of federal judges looked at it and said, we think they're still open.
So there's no limitation. They could be 25 years later. Yeah, I guess it depends on one's vitality, but
right.
Right. So there is no limitation pre-Maine's.
So there's no limitation pre-Maine's. The statute itself, the gatekeeper statute, has no time limits. Maine said, you know what, from now on, here and after, it will be 30 days. So, but it doesn't say anything about anything before that. And that's—
Then the court in Nassar said that Maine's was prospective. So
The
one
court did say
one
it was
case.
prospective.
but so
And
it's
that's what
prospective.
Maine said. So that's really our position. And it's, and, you know, I have no objection to saying, okay, let's kill all of these prior these prior motions for new trial and require gatekeepers, but within 30 days, but starting from the date of this decision. So that's really my position. There is no analogous case law in Massachusetts. There's nothing that really answers the question. I think this is just an open question that this court needs to answer.
If it's
And
an
I
open
can't-
question, if it's an open question and we're looking at the reasoning of Maine's, why wouldn't we answer the question? No. Your
Well,
client,
I think we answered that question. We can answer that question. Yes, the 30-day limit applies, but we've never said that it applies to anything before Maine's. So these pre-Maine's
but then we
cases,
could go on, couldn't we then go on to say, here's why it actually does apply to cases that were open before Maine's? Here's why it does. We're going to look at the reasoning of Maine's and say that it doesn't make sense to have left those other cases open.
well, you could, but the thing is, the decision itself, if you read the decision itself, the plain language of the case says that post-2000, post-Maine's, any motions for new trial have 30 days, but it doesn't say anything about those pre-Maine's cases. So there's no notice provided. And that's really the problem. And, you know, when you have, again, in this case, you have a pro se litigant. But even if you don't have a pro se litigant, if I were handling this case and Maine's came down, I would probably say to most clients, I don't see that it applies, but just to be safe, let's get rid of all of these pending gatekeepers. But for a pro se looking at this, he doesn't really, he may not understand that. And, you know, again, you had some very sharp federal judges who said, yeah, this doesn't seem to apply pre-Maine's.
Well, did Judge O'Toole say that? I thought he just certified a question.
He certified a question, but he didn't know the answer.
And that's what
And-
we're here to do, answer it.
Right. Right. And you know,
this
he
an
looked
all
at
or-
it and
Counsel, is this an all or nothing proposition? Like, let's just say we agree with you that Maine's was unclear at the least. Wasn't there a pre-Maine's reasonableness standard, or is your position that there was just an unlimited time limit? Unlimited
there was-
time.
I think there was an unlimited time limit. You know, there are a couple of things where this court, one or two things, the only thing I can think of is a motion to revise and revoke, where this court said, well, it's got to be brought within a reasonable time. But there's sort of that's sort of a unique situation where revise and revoke applies where you know, you have to look at whether there were factors at the time of sentencing. So obviously, you know, if you wait 20 years for to bring a revise and revoke, the sentencing judge is not likely to be around. Nobody's likely to know what the factors are that might have been missed at the time of sentencing. But in this case, any single justice can look at this and say, is this a new and substantial issue? Now, it's not clear. There were 10 motions for new trial filed between 1982 and 2017. Depending on how you look at it, anywhere from 5 to 10 of them, possibly all 10 of them, were addressed in gatekeeper petitions. Justice Seifert handled the 2017 gatekeeper, and there's no reference to exactly what was, you know, there's no new and substantial issue. But when you look at the gatekeeper petition itself, there are references to some of the earlier motions for new trial. So I think, I'm not sure, but I think the Commonwealth's position might be that all 10 of them have already been decided, you know, were decided in 2017. That's not critical for this analysis, because if the 30-day limit applies, then the 2017 gatekeeper, that would, a lot of those wouldn't have been timely. But if it's only 5 of them that were addressed, then Mr. Mandeville should have 30 days to go back and file a gatekeeper as to the ones that haven't been filed. Unless there are any further questions, I will.
What do
submit
you
the-
make of the
Yes.
last sentence of Nasser in the footnote 2? What do you understand the last sentence of footnote 2 to say?
I don't have it. I
Yeah,
don't
let
think
me-
I have.
I can read it to you. Manifestly, Nasser did not file the instant gatekeeper petition within a reasonable time. Moreover, so I guess, what does that mean to you?
I think what-
If it goes back to Justice Wendland's question, is there another standard in play or not?
Well, I don't think that was absolutely clear because, again, that Nasser had sort of unique circumstances where it was filed and it was dismissed for lack of prosecution. And then 25 years later, the defendant filed another gatekeeper referencing the earlier one. So I think the fact that the earlier gatekeeper had been filed and not pursued, I think that may have been at play in Nasser. That's how I would distinguish Nasser.
Any other questions? Okay, thank you so much, Mr. Curran.
Thank you.
Mr. Ravitz.
Thank you. Randall Ravitz for the respondent. This court should inform the federal district court that gatekeeper petitions challenging pre-Mains decisions denying new trial motions were in fact required to be filed within 30 days of Mains's issuance. The Mains court must have intended to impose such a requirement. It's not reasonable to conclude that the court instead meant to afford an unlimited time for challenging prior denials at the same time that it prescribed a strict 30-day rule governing gatekeeper petitions generally. And this is clear for several reasons. First, the Mains court emphasized finality and consistency in its announcement of the rule, and it discussed the importance of finality elsewhere in its opinion. It also
But Mr.
cited,
Ravitz, as you well know, Rule 30 has no time limit and 33E has no time limit, correct?
true, but there is, the 33E system builds in a restriction on the ability to obtain gatekeeper review to obtain review by the full court of the denial of a Rule 30 motion. And of course, the Mains court clearly adopted a 30-day rule at the very least for petitions
Post-Main.
generally.
Right.
And so,
That's post-Main. So I mean, the position you take is the position that Justice Spina took in his single justice decision in Nassau, correct?
that's right.
Basically, we're going to call in all markers, you got 30 days. But then the Nassau decision doesn't do that. It essentially, it kind of hedges, to be blunt about it, but it says it was prospective. So we have the court using language of here and after, and it's prospective. And then we have the court kind of doing both things at the same time in Nassau. So what do you make of the language of the prospective and the here and after language?
Well, we would say what the court meant there is that someone who had a pre-Mains denial would not be told at the moment that Mains is issued, you're already foreclosed. That's what it meant by here and after and prospective. But it meant that the period would not be found to have commenced before Mains. So it's as though the period had been told up until that point. And if in fact what the court meant was that someone in Mr. Mandeville's position would have an unlimited amount of time, then you should be able to plug that into the sentence in Mains where it announced its decision and have it work. But instead, what you would see is that then the court would be saying, in the interest of consistency and finality, we are going to give a 30-day period of time for people after the decision, but we're going to give an unlimited amount of time to another group of people. How could that be in the interest of?
Right, that's what I was gonna ask you. So we have them saying that in the interest of finality, we discussed that, but the consistency factor the court relied on in Maines is treating each defendant the same, correct? That's the consistency. So
Right.
not giving some defendants a 30-day limit and other defendants no limits.
Right. That's right. And so if one were to try and plug in this unlimited time rule or these two separate rules into Maines, it simply wouldn't work. And of course, right after the Maines court announced its rule,
So will you concede that Maines is at the least unclear?
we would say that it's not unclear when viewing everything in context. So that, in other words, the term hereinafter meant that people would not be told that they're foreclosed on the day that Maines is issued, but that the period won't be found to have commenced before Maines. And
And
it's,
so I guess maybe, but then in Nassar in 2009, the court is saying, albeit prospectively in reference to Maine.
right. And that's, we view that the same way we view hereinafter, in that what the court was saying was that people were not foreclosed on the day of Maines, but that doesn't mean that they would be
You
given an
think that that
unlimited amount of
is-
time.
You think that is clear from both of those opinions then?
It is looking at everything in context. So for example, where the Maines court said in the interest of consistency, finality, and then they cited a case where it says there must be a reasonable moment for a judgment to become final and a time beyond which further challenges must be barred. And it discussed finality elsewhere in its opinion, and it took a particularly hardline approach and rejected proposals offered by both Maines and the Commonwealth that would have been more lenient, looking at everything together and combined with the general principle of diligence that is found in various areas of the
Counsel,
criminal.
if your position is correct, that it's crystal clear from Maines that it meant to apply in the way you're suggesting, why would the court in Nassar then reference the 25-year delay in filing the motion, the gatekeeper on the motion for the new trial? I mean, why wouldn't the court have just said, this is, you had 30 days after Maines and you're out of time. Instead, the court seems to say in that footnote, you're 25 years late. It's not reasonable. And we know it's not reasonable because in Maines, we said 30 days. So you've known for a while that 30 days is our benchmark for reasonableness. And here you're 25 years late, manifestly, it's unreasonable. Why wouldn't the court have just said, if in fact your position was correct, why wouldn't the court just say, hey, you had 30 days after Maines?
Well, as we read the footnote, the court was giving several reasons for its conclusion. And the first thing it said is that Nassar is in no position to argue that the single justice erred here. And the single justice there had issued a decision that read Maines just the way that we do. So that was the first thing it said. And then it added all these other reasons that it had been so long after the denial of the motion for a new trial, so long after Maines.
But the court in Nassar could have said, Justice Spina was right, there's a procedural default, it's over.
That's right, but it also looked like the court was hesitant to rule on whether a procedural decision by a single justice could be reviewed by the full court. It left open that possibility, but the court made clear that it did not want to expressly issue a holding about the procedural ruling. So that would be another reason why the court did not approach the issue exactly the way that you just said. But if there was in fact an unlimited time rule, then much of what's stated in that footnote wouldn't make much sense. There would be no basis for saying that he didn't file the gatekeeper petition within a reasonable time. If he had an unlimited amount of time, then it couldn't be
Counsel, actually,
unreasonable.
that brings me back to the question I asked your brother, is this an all or nothing proposition? That is, pre-Maines, was there a reasonableness gloss to the time for which you could bring the gatekeeper?
There, we don't know of any such rule. There was the rule of appellate procedure saying that a notice of appeal should be filed within 30 days, but of course a gatekeeper petition isn't the same as a notice of appeal. And the court in Maine's recognized that Section 33E itself does not include a deadline for filing a gatekeeper petition.
But could
However,
I follow up on Justice Wendland's point? Post Maines, is there a reasonableness rule? And does Nassar incorporate that reasonableness rule? I mean, Maines could have been a lot clearer, but if you're bringing something 25 years after Maines, you're out of luck because it's unreasonable, because the logic of Maines meant, get your filings in. So I guess is in taking Justice Wendland's sort of rule, meaning there was a reasonable risk rule after Maines, and that's reflected in what Nassar decided. Does that make sense?
I think at the
Hopefully
very,
there's an Alice in Wonderland quality to it, but I'm just trying to make some sense out of it.
well, I think that what the Nassar court was saying was that at the very least, there's a reasonableness rule, because it wouldn't make sense for it to make reference to that concept if it wasn't. But then the court also suggested that it did not see error in Justice Spina's reading of Maines, but at the same time, it did not go so far as to issue a holding in that regard, which would have opened up the question of whether the full court should properly be reviewing procedural decisions issued by single justices.
Counsel, if there is a post-Maines reasonableness rule akin to what's in the footnote in Nassar, when does the statute of limitations for EDPA start?
Well, there would need to be, I would say, some decision from a state court about whether a filing was reasonable in order for the federal court to know whether in fact.
In this very case, how would the District of Massachusetts know if we said there is a reasonableness rule post-Maines? How would the District of Massachusetts know whether or not the EDPA was ripe or the statute of limitations had run?
Well, there should be a decision from a state court as to whether a petition was timely or not, whether it satisfied the reasonableness rule or not. However, I will say this, that Mr. Maines filed his 2017 gatekeeper petition, which challenged the first two motions for new trial, more than 7 years after Nassar. And the Nassar court said that Nassar was unreasonable, right? because it was more than 7 years after Maines. I'm sorry, did I?
So does that answer Justice Wendland's question, which is that it might have been a difficult question about the time Nassar's decided, but we're now 12 years later. So all of these things are past the statute of limitations at this point. So it may have been a hard question before Nassar, but it's not anymore because anything now is too late.
We'd say at the very least, that's the case.
Mr. Crehan suggested that perhaps when Justice Abrams wrote that footnote in Maines, that she didn't contemplate that there would be cases that would fall within this gap. Let's say that's accurate. Why isn't he right that the average pro se litigants really on no notice post-Maines to expect, oh, well, this decision came out from the SJC, let me get going. I've got 30 days to file my gatekeeper petition.
Well, a couple of things. One, I don't know how Justice Abrams could not have contemplated it, because if somebody had received a denial of a new trial motion the day before Maines, they would be in this category that we're talking about. So there really had to be people in this group at the time that Maines was issued. Also, the Maines decision itself spent close to 2 pages in the context of waiver talking about the importance of not relieving pro se litigants from the same rules applied to others. And in fact, one of the things they said about Maines himself was that he had shown that he can litigate, that he knew how to bring a motion for new trial and a gatekeeper petition. And so it's no excuse for him not to be subject to the waiver rule. So it would be hard to then read Maines to say that somehow there was an implicit exception for pro se litigants, or at the very least that the Maines court did not contemplate and did not take a strict position with respect to pro se litigants. But also beyond that, we're talking about people who had already brought a challenge to their conviction, and that challenge had already been fleshed out through a motion for a new trial. And so this is somebody who has an incentive to continue on with their challenge, and somebody who's already fleshed out the arguments in support of their challenge. And on top of that, as I said before, there's a concept of diligence and promptness that runs throughout the law. We see that in deadlines and statute of limitations. Even in the Rule 30 context, where the rule says the motion can be brought at any time, there's also case law saying that if it's brought too long after the conviction, that could be taken into account as a reason to deny the motion for a new trial. So even in the most lenient rule that there is, timing-wise, there's still a concept of diligence and promptness. And so even the pro se litigant should be aware of that and should take that into account.
Does anyone have any further questions? Okay, thank you very much, counsel.
Thank you.